You 4 years for an aggravated assault with a deadly weapon when it really should be because you want to do crazy things at the jail with inmates who are just trying to serve their time. And then you pick it on somebody, I read in here, who may be autistic. And then you're not even brave enough to do it yourself. You get other people to help you. And then you're saying someone told you to do it. And that's silly in and of itself. And now you're going to prison for 4 years. Do you want to be picked on in the prison? All right, what's wrong with you? You like somebody doing that to your mom or your father? Exactly. I don't understand. When people go to the Bexar County Jail or they're in custody, people are just trying to serve their time. That doesn't give you any right to be a bully. You understand?
Yes, ma'am.
So again, I'm asking you, what is wrong with you? Why would you pick on someone? You ever heard of the song Leroy Brown? When you bully people, guess what? There's always some bigger bully out there. There's always somebody else who can beat you. Inmates who are just trying to serve their time. And then you pick it on somebody, I read in here, who may be autistic. And then you're saying someone told you to do it. Now you're going to prison for 4 years. Do you want to be picked on in the prison, Robles?
Yes, ma'am.
All right. Counsel, have you received all the discovery in this case? And did you review that discovery with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Robles, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. The state filed a motion to amend the indictment to add a count 2 for an aggravated assault with a deadly weapon.
If we have no objections to that, Judge, we also waive the 48 hours of passing for the indictment. It's not reading that, it's just amended. We have no objections, Judge.
All right. Mr. Robles, do you understand that that amendment to the indictment is a substantive change? Do you understand that?
Yes,
and do you understand your attorney has the legal right to have a chance to prepare for jury trial once there's a substantive change has been made to an indictment? Do you understand?
Yes, ma'am.
All right. Knowing that, do you still wish to proceed?
Yes, ma'am.
All right. And they have the complainant as Michael Villarreal.
That is true, Judge. That is the name of the complaint.
And we waive any potential conflicts.
All right. And so I'm assuming that's not you, Mr. Villarreal.
It is not, and it is somebody that I am not related to by knowledge.
Okay. Do you understand with the amendment to the indictment, the state is proceeding on aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2 only. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There's an affirmative finding of a deadly weapon. There are no applications, and there is to be no contact with Michael Villarreal. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
To count 2 in the amended indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge. We just asked if you follow this plea agreement.
All right, what's wrong with you?
Give me one time, please.
I don't understand. When people go to the Bexar County Jail or they're in custody, people are just trying to serve their time. That doesn't give you any right to be a bully. You understand?
Yes, ma'am.
So again, I'm asking you, what is wrong with you? Why would you pick on someone?
No, ma'am.
Have you ever heard of the song Leroy Brown?
No, ma'am.
In those lyrics, Leroy Brown is the baddest man in the whole town. And you know what ends up happening to Leroy Brown?
No, ma'am.
He looked at the wife of a jealous man, and everybody was afraid of Leroy Brown. But then you know what they said at the end? That guy got in a fight with Leroy Brown, and Leroy Brown looked like jigsaw puzzle with many pieces gone. So when you bully people, guess what? There's always some bigger bully out there. There's always somebody else who can beat you. And I want you to realize people are just trying to live their life. They're hoping that they don't have to deal with nonsense from you and nonsense from other people at the jail. When people go to the Bexar County Jail, guess what? They're just there to serve their time. And we are not in a society of savages where people are supposed to go to the Bexar County Jail to get beat up and harassed. They're just there to serve their time. If we were living that type of society, guess what? We wouldn't have a jail. People would just handle their business on the street. And what you did to this individual with help from others was cowardly and it was wrong. Do you understand?
Yes, ma'am.
How old are you?
18.
When are you going to get your life together? Because right now you're going downhill. No, it's not okay. You are going downhill. You're before me and you want me to give you 4 years for an aggravated assault with a deadly weapon when it really should be because you want to do crazy things at the jail with inmates who are just trying to serve their time. And then you pick it on somebody I read in here who may be autistic. And then you're not even brave enough to do it yourself. You get other people to help you. And then you're saying someone told you to do it. And that's silly in and of itself. And now you're going to prison for 4 years. Do you want to be picked on in the prison?
Yes, ma'am.
Do you want to be picked on at the prison and bullied at the prison and beat up at the prison? Well, if I don't wish that on you, but if that happens to you, then you need to be thinking about what you did to this person. You understand?
Yes, ma'am.
Where are your parents?
He has an adoptive mother, and I believe he's just recently had contact with his biological father.
My biological mother.
And I'm going to tell you what I tell everybody. People come to me with sad stories all the time. At some point, your actions are your own. They're not to do with your past because everybody's had a hard life. I've had a hard life. I'm sure your attorney's had a hard life. State has had a hard life. People in jail done had a hard life. So at some point, the actions that you take are your actions. And it's not because I'm from a broken home or I've been adopted or I went to foster care. Do you understand?
Yes, ma'am.
All right, this is what the court is going to do. 4 years prison, affirmative finding of deadly weapon. There's a $1,500 fine. Time and money will not run concurrent. There's to be no contact with Michael Villarreal. I don't know how they're going to do that at the jail, but if you could make sure, I'm sure there's some kind of system, make sure he doesn't have any contact with him. And do you have any siblings?
Yes, ma'am.
How would you like somebody doing that to them? Exactly. How would you like somebody doing that to your mom or your father? Exactly. You wouldn't want that. Is there anything else with sentencing?
Judge, he just has an MTR that I think we need to resolve with the court.
All right. Let me know when you're ready. All right. The court is calling 2021 CR 2310 State Texas versus Sabian Robles. Parties announced, please.
Michael Villarreal for the state.
Orlando Gostin for defense.
All right. And are you Sabian Robles?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Sabian Anthony Robles who was placed on deferred adjudication in 2021 CR 2310 for the offense of theft, $2,500 to $30,000 of a vehicle on April 13, 2021 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 40 in Bexar County, Texas. The defendant, Sabian Anthony Robles, did then and there failed to report weekly to the supervision officer as directed for the weeks of May 9th, May 16th, May 23rd, May 30th, June 6th, June 13th, June 20th, June 27th, July 4th, July 11th, July 18th, and July 25th, 2022 in violation of condition number 40.
How do you plead to that? True or not true?
True.
The state would waive the remaining allegations.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading to the violation of condition number 40, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Ma'am.
Knowing that, do you still wish to plead true to violation of condition number 40?
Yes, ma'am.
Court will find violation of condition 40 true. Is there an agreement?
Yes, Your Honor. Agreements to grant the state motion, enter adjudication of guilt and it says punishment at 107 days confinement in the Bear County Jail pursuant to section 1244 of the Penal Code.
Is that the agreement?
It is, Judge.
Yeah, they did tell me that, unless it was part of an
Just
act.
a moment, Miss Embry.
Okay,
All right, are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes, ma'am.
All right, probation, was there any restitution in this case to Sierra Diaz? All right, no problem. I don't know if there was ever any, I know restitution was ordered, if any, but I don't know if there was ever any notice of restitution given by the complainant. The court will follow your agreement, grant the motion, find you guilty, sentence you to 107 days in the Bear County Jail under 1244, give you credit for any time served. Is there anything else with regards to sentencing?
No, Judge.
All right, good luck to you.
Thank you, Judge. Maybe we can be excused.
Yes.
He has 18 arrests resulting in 11 felony convictions. He's been placed on community supervision 5 times. He's been revoked 4 of those times, 10 years, and he's applying for probation and we're opposed, correct, Judge?
Yes, he's applying for deferred adjudication and also community supervision, if not deferred adjudication.
Understood. Judge, I think the biggest thing is dating back to 1994, Mr. Delarosa has
2022 CR 3521, State of Texas versus Armando Delarosa. Can I have parties announced for the record for the state,
Ryan Gerber for the state of Texas.
for the defense?
You can knock it up for the defense, Judge.
And are you Mr. Delarosa? All right, Mr. Delarosa, you entered a plea to count 1 on May 9th. That was a plea of no contest. You applied for deferred adjudication. The court found there was sufficient evidence to find you guilty. The state waived count 2 in the repeater paragraph. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. The state opposes your application, and they are taking 2 cases into consideration. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
All right, any objections to the PSI report from the state?
None from the state.
Defense, any objections to the PSI report?
Just one part, Judge. When we're talking about gang affiliation, I spoke with my client about it. They still have him with the Hermanos Pistoleros. He claims he has not been with that gang for quite some time, that he's been trying to get that, I guess, fixed over at the jail. They're still ranking him as that, but he's saying he is not associated. So other than that, that's it.
All right, state, do you have any witnesses?
We don't, Judge.
Defense, do you have any witnesses?
Just argument.
All right, then state you're opposed. The court will hear argument.
We are, Judge. Judge, I think in this particular case, my understanding is the plea agreement was we're asking for 10 years and he's applying for probation and we're opposed, correct, Judge?
Yes, he's applying for deferred adjudication and also community supervision, if not deferred adjudication.
Understood. Judge, I think the biggest thing is dating back to 1994, Mr. Delarosa has he has 18 arrests resulting in 11 felony convictions. He's been placed on community supervision 5 times. He's been revoked 4 of those times. He's been in and out of prison, it looks like, for his entire adult life. This is a case where I think that he has been in the system for so long that I don't think he's a good candidate for probation. Other judges have taken chances on him on probation, and it seems as though every time he has been revoked for those probations. In addition, there is 3 cases he's here for, 3 felony cases. 2 of them are being TIC'd. He's received the benefit of the bargain in this particular case with us lowering his exposure to 10 years. We'd ask that you sentence him to 10 years and you deny his applications for probation or deferred.
All right, defense.
Judge, although there is no dispute that my client has a long criminal history, as you see in the PSI, he also had a very difficult childhood. Drugs seem to be the main problem here. He has come to terms with his addiction. He understands that he needs treatment. While he's been incarcerated, Judge, he has been very, very proactive, and not only in Narcotics Anonymous, trying to get a referral for Haven for Hope, but he has a slew of, more certificates than I've ever seen any client hand me. I'm going to show them real quick to the state judge, because I'd like to offer them to the court over you.
The Gatorade never left the building.
and neither did person.
Okay.
All right.
Yes. All right, so these are not being offered into evidence, it's just for the court to review?
Correct, Judge.
We have no objection. State.
All right, just give me a moment to review these. Thank you.
My client, prior to being incarcerated on this, also had a job at the Spin Express as a laundromat. He has expressed to me that he's still waiting for him. If he were to get out, he's ready for treatment. He understands that he's not going to get away from this lifestyle without treatment. I've expressed to him and gone through the Taffy Val saying that SATIF is what is being requested. He's asking for a chance to go through lifetime judge, but understands that if he needs to do SATIF, that is what needs to happen. And he also wanted to address it.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Could you state your name for the record? All right, what would you like to say to the court?
I know that my history is very, very long of criminal activities. I've been addicted to drugs since I was 10 years old. I've been fighting my addiction for a long time due to traumatic stress I've had when I was little. Very little girl that we're looking for when I was picked up. We're looking for her in the farm with us. She left me the backpack.
She left you the backpack and she left you digital scales? And she left you digital scales. That's what you're talking about.
And I'm trying to, when we put them in the truck, put them in the trunk, and that's exactly what happened.
You put digital scales in the trunk?
Yeah, because I didn't want them. They're not mine. So I was getting rid of them out of my motel room because I was trying to leave.
All right. Any questions, defense?
No questions, Judge.
State any questions?
No, Judge.
Just a little argument.
All right, the court will hear argument. I've heard the argument from the state. What is your argument?
Judge, and I know we've just gone through extensively his criminal history. A lot of these cases were sentenced at the same time. I expect what happened was he was potentially on probation, maybe picked up other charges, and they were all consolidated together. Sometimes it takes an individual hitting rock bottom before they start to try to claw their way back up, Judge. I will just point again to my client's actions while he's been in custody. He didn't just sit there feeling sorry for himself. He has started to try to get treatment to counteract the effect that methamphetamine is having in his life. He is ready to do treatment, Judge. If this honorable court blesses him with probation, he'd be ready to go straight. Let's stay in custody and go straight to SATIF, Judge. I believe that only through treatment will we break this cycle of him being recharged and incarcerated.
All right. Mr. Delarosa, I'm not going to grant you deferred adjudication. I'm going to find you guilty. They do have a therapeutic community at the prison. What I can tell you is therapeutic community will not extend your time at the prison. If I were to sentence you to 10 years, you're not going to be extended more than 10 years because you decided to be in therapeutic community. I have no authority to force them to place you in a therapeutic community, so you'll have to ask for it. You understand? So would you like to be placed in the therapeutic community?
It's not.
All right. So I'm going to find you guilty, sentence you to a $1,500 fine, time and money to run concurrent, taking consideration 2022 CR 2011 and 2022 CR 2012. I'm going to ask that you be placed in the therapeutic community. Would either party like to argue with regards to, well, I guess the agreement was for 10 years. All right. And I'll send you to 10 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? And because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you, Mr. Delarosa.
This case is a reminder that judges don't just look at the crime itself, they look at the choices that led a defendant into that courtroom. Judge Raquel West made it clear that difficult circumstances, a troubled past, or outside influences can explain behavior, but they don't excuse it. What seemed to frustrate the court most was the defendant's decision to target someone perceived as weaker while refusing to take full responsibility for his actions. In the end, that combination led to a 4-year prison sentence and a powerful lesson about accountability. But what do you think? Was the judge's message exactly what this defendant needed to hear, or did the court go too far in making an example out of him?